Welcome to the Ottawa Business Journal's live broadcast of what can happen when you don't have a carefully contracted contract. I'm Michael Curran from the Ottawa Business Journal. Thanks for joining us today. It's back to school season, it's back to work season, and it's back to live broadcasts from OBJ and our partners. We've got hundreds of live viewers across various platforms, including YouTube, LinkedIn, Twitter, now called X, and Facebook. And we've got a great show lined up for you today. And that's because we're talking about something that's a real ongoing challenge for employers. I'm talking about staying on top of employment law. Of course, employment law is constantly evolving based on case law that influences the rules around how we work with our teams. Today, we have our friends from Emond Harnden, a boutique law firm based here in Ottawa that supports many of the city's best-known organizations with their employment and labor law. Emond Harnden is back today to review 3 recent cases and help keep your employment contracts up to date, which is a really important thing. I'd like to introduce our first guest. Here is Paul Emond, a partner with Emond Harnden. Welcome, Paul.
Okay, nice to be here. Thanks for having me.
Yeah, thanks for being here, Paul. I'm looking forward to this. And we have an associate from Emond Harnden, Zoriana Priadka, a recent addition to the firm. Welcome, Zoriana.
Thanks for having us.
You're the new kid on the block.
That's right. Right. So
Okay.
New to the firm, but not quite new to the law.
I know that, Mark. And you're going to demonstrate all, of course, the expertise you bring to the table. Paul, we're going to start with you just by giving us a little bit of a preview at a high level of what we're talking about today.
Sure, thanks a lot. So, as I've seen throughout my career, and as many of you are probably know very well, employment law is constantly evolving, and it's not always easy to stay up to date on the changes that are occurring. Although it can be challenging, it's also really important that you make an effort to stay on top of those changes, because the changes in the legal landscape can really have significant and costly consequences for employers. One particular aspect of employment law where this is particularly true is employment contracts. So, for example, when the law changes, provisions within employment contracts or even entire employment agreements may become unenforceable. So today we're going to be talking about 3 recent cases of the Ontario Court of Appeal that include some important lessons and takeaways for employers, especially with respect to contracts. So in Ontario and throughout Canada, employment law is sort of made up of 2 branches. It's made up of legislation like the Employment Standards Act, and then you have the case law, which is often referred to as the common law. And in the common law, a principle called stare decisis must be followed, which means lower courts have to follow the decisions of higher courts. So that's why these cases that we're going to cover are so very important, because in Ontario, they are essentially the law now that the Ontario Court of Appeal has made these decisions.
That's an excellent explanation. Thank you, Paul. And Zoriana, I wanted to check in with you. Some might be listening to this and saying, well, isn't that a little academic? And how does that influence me as a CEO, business owner, or director of HR? But there are real risks, like very real world risks here, right, Zoriana?
And we'll see that in the 3 cases that we're talking about today. But absolutely, the difference in having an enforceable contract that you can rely on termination, the difference can be devastating if you don't have one that has termination provisions that can be enforced. So in Ontario, easiest example is you have a contract that limits the employee's entitlements to just the statutory ESA minimums. The difference can be something like giving them a few weeks on termination versus giving them something like 2 years worth of pay on termination. So real world consequences, it's very important to have contracts that are binding, enforceable, valid, all of those things.
A few weeks, a couple of years, we just got everybody's attention.
Yeah, huge difference. Huge difference.
Yeah. All right. So listen, as advertised, we're going to go through 3 cases here, and I'm going to give everybody a quick preview of our agenda. In case number 1, we're going to be looking at the case of the missing termination clause. It sounds like a murder mystery to me. In case number 2, how changing job duties made a termination clause unenforceable. And in case number 3, what is consideration and why you need it to renegotiate a contract. Just a reminder to our live viewers that sometime around 12:25 Eastern, we'll be going to you with your questions. So I'm sure as you're listening to Paul and Zoriana, you'll have all these things popping up into your head, whether you're on YouTube or LinkedIn, for example. You can use those platforms to ask questions, and we'll get it here in our studio. So sometime again around 12:25, I'll be moderating a Q&A session with Paul and Zoriana. Well, let's get right down to business. Case number one is Montecero versus Metro Freightliner Hamilton, Inc. And Zoriana, you're going to kick things off. Go ahead.
So this is a fairly interesting case. It actually revolves around Mr. Monterosso. He was an independent contractor. He provided services under his company called Truck Leasing Canada. So he contracted with Metro Freightliner Hamilton and a few other companies to provide these services under his own company. And the interesting part of this case is that the agreement that he entered into was a fairly long fixed term contract. So it was for 72 months, fixed term, entered into this agreement. Couple months in, Metro Freightliner decides, you know what, it's not working out. We want to terminate this agreement. The issue is that in this contract, there was nothing that allowed the company to terminate the 72 months contract early. There was no termination provision, nothing about what happens if, a few months in they wanted to end the agreement. There was no provision that allowed them to do so or stipulate what happens if it happens. And that was fatal for this case. So of course, Metro Freightliner says a couple of months in, look, it's not working out. Mr. Monterosso says, nope, you can't do that. He decides to sue and asks the court to award the remainder of the contract. So at the time, there was 65 months of pay that was remaining under this contract. He decided to pursue the company for that amount. And at the trial level, so this was a Court of Appeal decision that we're looking at, but at the trial level, the judge found that yes, there's nothing in this contract that allows the company to end or terminate the contract early. Without that termination provision, you're just simply not allowed to do it. The company therefore owes the remaining 65 months, which came to it was over $500,000 plus 80. So again, potentially devastating consequences for not having a good enforceable contract. The trial judge made it specifically clear that without that termination provision, it's very clear and unambiguous that 72 months is what was contracted for, and that's the remaining of that is what is owing. Of course, Metro Freightliner Hamilton decided to appeal. They were arguing a few things, but they were essentially pointing to some email exchanges before the contract was signed that seemed to imply something that said that there would have been, Mr. Monterosso would be paid up to the last day of active service. And they were pointing to these emails to say, look, he obviously knew 72 months may not be guaranteed. If we're talking about active service, that would imply we can end it early. Maybe there's nothing contractually in there in terms of a provision or an article, but he knew he knew that maybe we could end this early. And the Court of Appeal said, essentially, too bad. If it's not in the contract, it's not stipulated. There's nothing that we're going to be looking at in terms of the context of how the contract was drafted. And they actually pointed to the entire agreement clause in the contract, which said if it's not in the contract, if it's not there, absent any sort of fraud or misrepresentation, we're not looking at any sort of context. It has to be in the agreement if you're going to be relying on an early termination. Beyond that, an interesting element in this case is that at the trial level, the judge found that normally when a termination provision is, when a termination occurs, employees generally have a duty to mitigate their damages. And what that means is that they have to make reasonable efforts to look for other work, to reduce the amounts owing to them under a contract. The caveat here is with an employee who's terminated on a fixed term contract, they don't have that duty unless it's stipulated in the contract. And in this decision, we're looking at an independent contractor. What's interesting is that the Court of Appeals said, no, there's nothing that says independent contractors, when it comes to duty to mitigate, independent contractors on a fixed term, they still do need to mitigate. So that's kind of an interesting element of this case, but it didn't make a difference in the end. So the Court of Appeal said, sure, he had to mitigate by looking for other work, but there's no evidence he failed in that duty. So the employer didn't present any evidence of here's this job, here's this work that he could have done to mitigate the losses. They essentially said, we accept Mr. Monteroso's evidence that he made reasonable efforts, he couldn't find other work, so therefore the full 65 months is owing. So in terms of why this case is important and what it changes, most important thing is if you're going to have a fixed term contract, make sure you have enforceable early termination provisions. Otherwise, you're going to be on the hook for the remaining whatever compensation is under that contract. And the second thing is this case confirms independent contractors do have to mitigate their damages, even if it's a fixed contract. And lastly, if you were going to be arguing an employer that this individual failed in their duty to mitigate, make sure you have the evidence to show that. You need to actually say, here's this job, here's this contract that they could have entered into to obtain other payments. That would be a way to reduce the amounts owing. Otherwise, it's not gonna fly in court. Essentially, the judge will need to see evidence of failure for a duty to mitigate. So that about wraps up that first case.
And what a first case, Zoriana. I think business owners, entrepreneurs, managers have always been told, make sure if you're making someone an employment offer, contract offer, to have it reviewed by a lawyer. But this is such a powerful case. I mean, my goodness, to have an oversight of not having an early termination clause, hit a company's bottom line to the tune of $500,000. That is a painful penalty to pay. By simply not referring to a lawyer. I think it's fair to say, Zoriana, if an employment lawyer had looked at this, they would have very easily spotted the fact that the termination clause was missing.
Absolutely. That was definitely fatal in this case, and it's unfortunate because, again, the consequences were so huge. $500,000, 65 months of pay just because you missed a provision in a contract.
Yeah. What a way to grab everyone's attention here. And of course, $500,000 for a small company, and I'm not speaking to the size of Metro Freightline or Hamilton, but for a small company, that could be literally ruin the company's finances, make them insolvent, so on and so forth. Wow. What a great way to debut. And we got a great case coming up with Paul. Before Paul presents, I just want to remind everyone that there's a whole bunch of people active on our comment section. So keep on asking your questions. I'm sure they will. Your questions will pop to mind as the presentation's happening. Put them in early, and then we'll sift through them and a greater chance of getting your question on screen and answered by either Paul or Zoriana in just a few minutes. All right, Paul, it's time for case number 2. It's Celestini versus ShopLogics. And the key thing to focus on here for our audience is how changing job duties made a termination clause unenforceable. Tell us more, Paul.
Well, yeah, this case is Celestini versus ShopLogic, and the principle that's important to take out of here, it's got a very fancy name. It's the changed substratum principle at common law, and that's sort of what was at the core of the decision in this case, and we'll come to that a little bit more. But the result here, you'll see, was huge liability to an employer on the basis that the substratum of the contract that was initially entered into changed, and because of that, the termination provisions in the contract were held to be unenforceable by the court at the first level and the Court of Appeal. So with respect to this case, Mr. Celestini was a co-founder and former CEO of ShopLogic. In 2005, a venture capital firm purchased shares in ShopLogic from its founders, including Mr. Celestini. At that time, Mr. Celestini stepped down from his position as CEO, and he assumed the position of Chief Technology Officer, CTO, of the company, signing a written employment contract to that effect. The contract he entered into at that time, amongst other things, stipulated that if his employment was terminated without cause, he'd be provided with 1 month's written notice, as well as his base salary and group health insurance for 12 months. And he'd also be entitled to a prorated payment on account of his annual bonus. And this was to settle all claims that he would have with respect to his employment or the termination thereof. Fast forward 12 years, and ShopLogic terminated Mr. Celestini's employment without cause. They relied on the contract. They paid him out in accordance with the deal that they thought they had in place. But Mr. Celestini wasn't happy with that. He was of the view that the termination provision had become unenforceable as a result of the changed substratum doctrine that I was referring to. And to get in a little more detail, that common law doctrine states that provisions in a written employment contract that purport to limit the amounts payable to a dismissed employee may be unenforceable where there have been fundamental expansions in the employee's responsibilities after the employment contract was made, such that the substratum of the contract has disappeared or substantially been eroded. Or it can be implied that the contract couldn't have been intended to apply in the circumstances where the employee ultimately was the role they ultimately held at the conclusion of their employment when it was terminated. So Mr. Celestini chose to challenge the terms of his contract, and he sued ShopLogic. He was looking for a common law notice period of 18 months, so greater than the 12 months that was essentially provided for in the contract. On a motion on summary judgment, it was determined by the judge that the evidence showed that in 2005, the CTO role involved duties pertaining primarily to transfer of product and corporate knowledge within the company. So almost as if the plan was Mr. Celestini wouldn't be there long term. He was, there was a sale, he would stay on for a while, then he'd depart with his package. However, significant changes to his compensation plan were consistent with the fundamental and substantial changes to his role that began in 2008 under the direction of the new CEO. So turns out he didn't leave. He stayed for another 12 years. And starting in around 2008, he was given compensation increases as well as a substantially changed role. In particular, he took on new responsibilities such as managing important aspects of sales and marketing, directing managers and senior staff who were assigned to report to him, traveling to pursue international sales and other important responsibilities. As a result of that, the motion judge concluded that the substratum of the contract of employment disappeared and implicated the changed substratum doctrine, which left the notice terms in his contract no longer enforceable. So the motion judge found that Mr. Celestini was entitled to common law reasonable notice of termination and awarded him 18 months compensation. This included a total of $420,000 worth of damages. So this was on top of the essentially 12 months that he was already paid pursuant to his contract. And it included car allowance payments, bonus payments, lost life insurance entitlements. So you could see the implications of not entering into a new contract, perhaps when they could have at some point in the relationship, turned out to be quite costly. So on appeal, ShopLogic challenged the motion judge's conclusions on the substratum principle. They argued that it was inappropriately applied and that they erred in finding that any changes in Mr. Celestini's duties were sufficient to engage the doctrine. They argued that the judge should have found that the contract's termination provision continued to be enforced since ShopLogic had complied with it at the time of termination. There was also an argument on appeal that it's kind of an aside for our purposes related to how much in bonus Mr. Celestini was entitled to, but that's kind of an aside, as the focus of this for us is the change substratum principle. So in response to ShopLogic's arguments, the Ontario Court of Appeal concluded that the arguments they made were completely rejected. So Shop Logic wanted to make the argument that in order for the doctrine to apply, there has to be fundamental changes that result from a promotion, and that just couldn't apply in a circumstance where this was an executive. So there wasn't really a promotion, there was just changed duties, and the job title remained the same all the time. The Court of Appeal rejected that and held that it wasn't necessary for there to be a promotion or a change in job title in order for this principle to apply. And secondly, Shop Logic argued that the incremental changes in duties were not sufficient to invoke the principle. The Court of Appeal again rejected that, saying, first of all, the judge, this was an issue of mixed fact and law, and the judge concluded on the facts before them that the incremental change did in fact amount to a fundamental change, and therefore the change substratum principle applied in the circumstances. So in the end, the $400,000 plus was still owing to Mr. Celestini by Shop Logic. And in fact, there was the little aside portion, Mr. Celestini ended up with more in terms of his bonus entitlements as a result of this appeal, and the employer, of course, had to pay costs because they pursued the appeal and lost. So with respect to takeaways from this, this change substratum principle, it doesn't arise all that often, but it has been part of the common law in Ontario for several decades. And so it's important for employers to be aware of the existence of the doctrine and of the fact that it can be, in some circumstances, a reason to oust the termination provisions in employment contracts that they may otherwise seek to rely on. The decision highlights that although contracts might have been very carefully crafted to include important clauses such as termination provisions, they have to be reviewed regularly in light of changed circumstances, in this, which is the key point in this case, as well as changed law. So it is not only new law, but also, as this decision illustrates, changed circumstances that should cause an employer to consider whether they need to enter into a new employment contract. In this case, the inclusion of what's called an anti-obsolescence clause at the outset could have helped. And what that is a clause that says something along the lines of, regardless of what position or held or duties that the employee was responsible for at the conclusion of their employment, the termination clause would still apply. So that was missing from this contract. And additionally, it seems from the facts that there was increases in compensation, increases in duties, and if the employer had taken the opportunity to enter into a new employment contract with Mr. Celestini at some point in the employment relationship when duties were evolving and compensation increasing, they could have put a new employment contract in place that would have had an enforceable termination clause. So those were the key aspects to take away from this case.
Yeah, very interesting, Paul. And by the way, probably a story that is that happens quite often in Ottawa's technology sector. I've often seen, founders go to CEO and then back to a different position. But I was just going to get you to reinforce that last point. So, very interesting facts. What you would have recommended to the company, Shop Logics, is that at some point in that relationship that they would have written a new employment agreement. And I got the non-obsolescence or forgive me the word that you used, but your recommendation would have been you should have entered into a new employment contract.
Yeah, I mean, and Zoriana is going to be speaking about consideration in the next case that we're going to be covering. Okay. So I won't steal thunder on that point, but okay. I think here I like the contract was one that was written for someone who was part of the ownership group of a company that was purchased in a transaction. It was written seemingly with the idea that he wouldn't be there for 12 years, right? He was going to leave shortly thereafter, either on his own account or because they would let him go. But once his duties started to evolve and he was clearly with the company and working towards its future, and he was getting compensation increases as a result of staying there over time, the company should have realized, well, we should get a contract in place that reflects what he does for us now.
Yeah. Yeah.
And that would have saved them
Well,
maybe not 400,000, but it would have saved them a good amount of money, and at least they would have been more likely to be paying only what they thought they had to, as opposed to a surprise $400,000 more dollars.
Yeah. So interesting. Again, so a little bit of a lesson about contacting your employment lawyer here. If you're managing someone, if someone's on the team, especially at a senior level, I presume, and their job is significantly changing over a number of years, good to check in with your employment lawyer and say, do we need to redefine this relationship and bring a document up to date? Wow. Listen, we're going to move right into number 3. And it obviously very well planned here, because we're going to talk about something called consideration. I don't know what that means, so I'm eager to hear what it does mean, Zoriana, why it's so important. But the key point is, Zoriana, this term consideration can be used to renegotiate a contract. So it does does speak to the second case. But take it away. We're going to talk about Goberdan versus Knights of Columbus. Zoriana.
Yes, and this is probably my favorite case that we're discussing today, just because it's so unfortunate, but also very timely. And it's such a great reminder of the importance of consideration when contracting. So, before I get into in the case and specifically what happened, if an employer wants to update a contract or amend it, add new provisions, um, they need to provide what's called consideration. And contract law 101 is that for contract to have forms, you need to have an offer, acceptance, and that third element, consideration. Consideration can be anything like a raise, a signing bonus, some additional benefit, something of value that the employee receives that cannot just be continued employment. So if the employee is already working and you say, well, I want to update this contract, I'm going to add this new, update the termination provisions or add this new provision or what be it, you still need to give them something in exchange. Easiest things, signing bonus. Sometimes we see raises. If the employee gets a raise every year, that's a great chance to give them a new contract with updated enforceable provisions. In this case, unfortunately, consideration was not something that took place. So Goberdan versus Knights of Columbus. In this case, Goberdan was a field agent. He sold insurance through the defendant, Knights of Columbus. So when he was hired in 2011, Knights of Columbus gave him a contract. He signed that. And then years later, he signed a second contract in 2018 and a third contract in 2019. The trouble with those two, the second and third contract, is that Knights of Columbus did not give him anything extra in exchange for him signing contract 2 and contract 3. So no raise, no extra signing bonus, nothing other than just, here, we're updating the contract. If you want to keep working here, you need to sign. And that's what became fatal in this case, where few months after that third contract, the company, Knights of Columbus, decides, okay, we are terminating this contract effective end of April 2019. In response, Mr. Goberdan, even though he was a field agent, he decided, actually, I was an employee and I have certain entitlements under legislation as an employee, including termination pay, et cetera. And he asked for all these things. And unfortunately, there's differences at law when someone's considered an employee versus an independent contractor. Independent contractor, that's much more like a commercial agreement. The idea is that they're on sort of a even playing field with the employer when they're contracting, versus employees who are allowed a lot of deference. They really are essentially given contracts, told to sign. They don't really negotiate so much, and they have certain minimum rights under legislation like the Employment Standards Act that goes to things like termination pay, severance, et cetera, minimum wage requirements, et cetera. So interesting that this field agent made the argument, actually, I think I was an employee all these years. I want a package. He sued for wrongful dismissal. And an important thing to remember in this case is that it was a motion. It wasn't exactly a trial. So there was no, even though it went to the Court of Appeal, at the first instance, there was no decision on was Mr. Goberdin, was he entitled to wrongful dismissal damages? Does he win his case? Really, what happened in this case was the Knights of Columbus said, hold on. We're looking at contract number 2 and contract number 3, and we see that there's what's called an arbitration provision, which says that if there's ever a dispute in the contract, that instead of going to court, we're going to opt for private arbitration. So when Mr. Goberdin decided to file a court claim to say, actually, I want a termination package, Knights of Columbus brought a motion, which is like a preliminary hearing, to decide on the issue of, can he even do this? Can he sue us? Or do we have to go through private arbitration? So Knights of Columbus were saying contract 2 and contract 3 have these arbitration provisions that we're going to be saying should apply in this case. And unfortunately, what the motion decision judge found was that, okay, looking at contract 2 and contract 3, doesn't matter what's in them, they're not enforceable because Mr. Goberdin was never given any sort of consideration in exchange for signing. So forget the contract, doesn't matter what's in there, it's not valid, it's not enforceable. We're looking at contract number 1. There's no arbitration provision in contract number 1. So very disappointing in this case because it could have been easily avoided. Unfortunately, that was the decision that the motion judge made. And they also made a comment that, yes, he was an employee, not a contractor. He should have been given consideration. So the Knights of Columbus, when they brought this motion to decide if Mr. Goberdin can actually bring a court case, the motion is called the stay of proceedings. They said, let's put a pause on the court case. This should be in front of an arbitrator. The motion's decision was that the stay is refused. So court case continues. This does not have to go before an arbitrator. Of course, Knights of Columbus appealed. This went in front of a Court of Appeal judge who upheld the initial decision. They agreed with the motion judge and said, yeah, no, we do think that the lack of consideration issue is valid. Mr. Goberdin was not given anything extra in exchange for the arbitration provision that you're trying to enforce, so it doesn't matter that it's in there. And for that reason, he's allowed to bring a court case. There's nothing preventing him from doing so. With regards to that second argument that, the Knights of Columbus, they weren't happy that the motion judge had said Mr. Goberdin was an employee, not an independent contractor. The Court of Appeals said, well, it's still a live issue. He doesn't win his case. He's still bringing his case before the court to decide if he gets wrongful dismissal damages. So you can make your argument there. So they found that it was still a live issue. There's no final determination on whether he's an employee or a contractor. The important thing in this case is just that contract 2 and contract 3 did not have valid consideration, so we can't enforce the arbitration provision. It doesn't matter. The Knights of Columbus tried to make arguments like, well, we added other provisions that gave him a benefit. They were saying that originally the governing law said that, the law of Connecticut applied. They changed that to Ontario. And the court said none of these extra changes actually gave him a right or a benefit. It wasn't sufficient to count as consideration. So, unfortunate decision. The most important thing to remember from this is that if you want to have a valid contract, you need to have all 3 elements. You need to have consideration, otherwise it's not worth the paper that it's written on. It's not a contract, it's not enforceable, it's not binding. The easiest thing to do in this case is that had the Knights of Columbus given him something extra, a raise, a signing bonus, some additional extra thing, then they would have been able to enforce contract 2, contract 3. Without that, there's just court's hands are tied, no consideration, no contract, easy fix. Unfortunately, didn't happen in this case.
So interesting. I did not know that. So again, I think you said it very clearly, but I'll just reiterate. In contract number 2, contract number 3, there needed to be a bonus, an increase in compensation, something material. And because that wasn't there, their entire case effectively fell apart and was rejected by the courts based on such a small item, really, in the end, right, Zoriana?
That's exactly it. And that's why it's so devastating. It's like this could have been avoided, had they spoken to an employment lawyer who would have said, okay, great, we can update his contract, but you need to have this.
Yeah, great, 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 great. Well, so well presented, and each of those cases were so informative and taught me at least as a layman something new in terms of employment law. So wonderful job. We're going to now turn. We're a little bit into overtime, but we've got some time for questions for sure. Paula has been helping sift through them in the background. I've been keeping an eye on them. So I'm gonna pick out a couple of these, and yeah, I think this one, Paul, I'll go to you and I'll read it for you as I put it on screen here. It relates to the case that you spoke to, number 2, Paul. I think you've got an answer for this. Are we saying that every time an employee gets a promotion with more responsibilities, we need to do a new employment agreement? What say you,
That
Paul?
would, yeah, that would definitely be the best practice.
Okay.
Is when someone's promoted, you put a new employment contract in place. Now, if you have one of those provisions that I referenced earlier that says it doesn't matter what position this person is in at the time of termination, this termination clause will apply, then you'll still potentially have some protection if they're promoted. But the best practice is to put a new contract in place, because when they're promoted, that's your opportunity to fix any other problems that may have arisen in the intervening period of time due to changed case law, changed employment standards, etc.
Yeah, I get your point there, right, Paul? So not only because the person's changing roles, but because the period after which they're promoted might have been years, so there might need to be other language changes in the contract, not even related to the promotion, but just clean up other language. Is that right, Paul?
Yes, exactly. Like, for example, recently, uh, the provisions that are in many employment contracts out there, uh, the way they were written to limit entitlements to employment standards minimums upon termination. There was a Court of Appeal case a couple of years ago that basically said none of those are enforceable anymore. And that meant there's all these employees who are entitled to common law instead of employment standards. But if you had one of those employees being promoted, they're getting a higher job title, a raise, or some increased compensation package, that's your opportunity to fix that termination clause to make the end result be what you're expecting based on the way the law had evolved.
Okay, that's great. So, Ariana, we've got one related to case number 3, pardon me. And the question is just a point of clarification, I think. In the Knights of Columbus case, they would then need to revise all of their field agent contracts. Would you agree with that? So if they had renewed other field agents and contracts and not put consideration, I mean, they should have immediately after this negative ruling against them fixed the other contracts.
Well, and I hope they did, but in this case, all that matters is the contract between Goberdan and Knights of Columbus. So whether or not they amended other contracts doesn't really matter to his situation. But what a great opportunity to have all of them amended at this case. Anytime you want to update or change a contract where the employee is already working there or the contractor is already working, have that extra consideration, have those changes done properly. You can do it at any point, but to Paul's point, if you have a promotion anyways, where they're getting a raise, there's changes happening anyhow, that's the best opportunity to do so. You don't have to think then, okay, what's the consideration that I'm giving them? In that case, the raise is sufficient to bind the additional changes.
Excellent. And I think you'll say yes to this one, Zoriana, but we'll stick with you and that last case. We have this is from Margarita asking, we have the practice of signing a new contract in March of every year. We include a salary raise and make it conditional upon signing the contract. Is that enough to meet consideration?
Yeah, that's great. And that's
Yes.
honestly a great practice to have where, as soon as you have that raise, you can say, here's this new contract. You can add the new position. So we don't have a situation like case number 2. Talk about the change duties and so forth. Just mention that there's a raise. And then if they don't sign it, they don't get the raise. That's great. And
Okay.
that actually raises the consideration that you need.
Okay. Listen, I think we got time for one more question. There was a long one here that spoke to people who are, and I'm not trying to confuse the issue. So if I'm taking us on a tangent to say, like, that's a tangent, forget it. People asking about work from home. So, is that pertinent? Or maybe I'll ask that in a different question. Um, should from home be taken into consideration when employers are drafting employee contracts? You want to take a shot at that, Paul?
Yeah, they definitely should be taken into consideration. Like the location of work is something that should be addressed in your employment contracts. Any special rules that apply when somebody's working at home should be addressed in your employment contracts, or your employment contract in some cases could reference a policy that will apply to them, and that would be sufficient. But um, and for example, if an employer wants to have flexibility in terms of whether they could say, hey, employees, we want you to come back into the office, or we want you to be in the office at certain times, then that's something that should be in the employment contract. Because if you enter into a contract that says you're a remote worker working from home, and then you go and to unilaterally change that, then that would be a fundamental change, which could amount to a termination or constructive dismissal. And to relay it back to like the substratum concept that we discussed today, what you might have seen over the past few years is people who always worked in the office and their job has evolved into working remotely. And the issue that comes up a lot is, well, can I make them come back now? Well, it depends. Like that's not a simple answer. For some employers it would be yes. For some employers, no. It would depend on how that change was implemented and how it evolved, etc.
I'm going to ask you, we're way into overtime. I apologize, Paul, but I'm really intrigued by what you said. So, let's say a company has a bunch of employees who have been working there for, let's say, longer than 5 years. I say 5 years because it's before the pandemic. In the pandemic, health crisis, people need to work from home. Should a company literally consider revising? And now let's say the company's, sorry, I should add this part. Let's say the company's workforce is now in a hybrid type situation, which I think we're seeing a lot in Ottawa. Paul, should that company actually consider redoing all the contracts that, for example, are pre-pandemic, just to introduce location clauses?
Again, I think the answer to that is it's more of a it depends, because you'd have to gather all of the facts about the circumstances applicable to that employer and their employees. But perhaps entering into new employment contracts would be something that is recommended if it's going to become something permanent. If it's certainly that would be the case. Changed policies is definitely something that should be happening if your workforce is going to be working from home most of the time, if not all of the time.
Okay.
But employers who are in that situation with, well, now everybody's working from home, what do we do? I mean, it might be they're working from home and that's fine with us. What do we do? Well, think about that and consider it. There might be some things to do. You might be an employer who's everybody's working at home, but that doesn't work for our business. Can I bring them all back in? Well, that's another, set of advice in terms of whether the way you rolled it out allows you to roll it back simply or not. On top of the more practical, how will your workforce react, which is not purely legal, but
yes,
it's all related.
Yeah. Well, I think there should be an instinctual reaction from employers if anything is changing, or if they've got these issues, to seek out expert advice. Listen, Paul, we're going to move into our final phase, and you're going to provide our viewers, thank you for sticking with us, by the way, some key takeaways, and then we'll wrap this live broadcast. So go ahead, Paul, take it away.
Okay, so I mean, 3 key takeaways then would be: the first, there is value in a carefully crafted contract. I think you could take that from the first case that Zoriana discussed. That was a term contract that didn't have an early termination provision, and it didn't have a provision that required the contractor to mitigate if it was terminated early. So that wasn't very carefully crafted. It could have clauses could have been included that would have protected the company much more so than what they ended up with, and it would have been quite easy to include those. The second key takeaway to take from today would be even carefully crafted contracts should be reviewed regularly. And this comes from the case that I discussed. They should be reviewed regularly when their circumstances change, like things that have changed in the employment relationship or just the duties of the employee. That should trigger a, hey, let's review. Should we change something here? Is there an opportunity to do that? Do we need to make a change to protect ourselves? And the other circumstance where this comes out, not from a case that we discussed today necessarily, but there are sometimes legal changes that make a term in a contract no longer enforceable the way that it was when it was first implemented. So when those changes occur, a review of the contracts and a decision as to whether you need to update them should definitely be on an employer's checklist. And then the final takeaway from the last case that Zoriana spoke about is don't forget consideration. And I mean, this comes up regularly in what we do. It's sort of one of the key things. And so the case Zoriana spoke about was sort of during a relationship, getting someone to sign another contract doesn't necessarily mean that it's enforceable. You need to provide additional consideration, and an analysis should be that has to be thought about. What are you going to give them of value for them signing this contract? The other way that it has always come up throughout my career is, and I still see employers making this mistake, is if you have employees sign an employment contract, get them to review it and sign it before they start working for you. Because if they walk through the door and start working for a little while and then you get them to sign it, well, there's no consideration for that because they were already working for you. And so those are the three simple key takeaways from today.
I've heard that one before too. Always sign the employment law before the new employee starts. Okay, so I've learned a lot here. I've learned that case law is forever changing employment law. Number 2, you gotta have a termination clause. Number 3, if people are changing jobs, consider a new contract. And Zoriana taught me that consideration, when you're renewing a contract, you need consideration. If you don't have consideration, it's not worth the paper it's written on. So that's all great. Now, just because I understand these simple things doesn't mean people shouldn't talk to an employment law. So we're going to bring your contact information on screen. So we'll do that. Again, please contact an expert. If you've got questions on this, you can see Paul's phone number, email, same with Zoriana. Listen, Paul and Zoriana, you've done a great job. Thank you very much for participating today. I learned a lot. I'm sure many people in the audience learned a lot, and we look forward to more employment and labor law presentations from Emond Harnden. You do such a great job. Thank you so much for being with us today.
Thank you so much for having us.
Bye-bye.
Bye-bye.
All right, we're going to wrap up here. I want to remind you all that this is a live broadcast, but once we wrap up this live broadcast, then it is available in a play on demand. So if you're on YouTube, bingo, it becomes a replay link. If you're on LinkedIn, ditto. So I'd encourage you, if there are other people in your organization that need to hear the information and learn about the information we presented today, please share that link. If you registered, one of the benefits of registering for these is we will send you the link. So then you can send it to your colleagues so you don't have to go hunting for it. That's all the time we have for today. On behalf of all my colleagues at Ottawa Business Journal, I want to thank you for tuning in. There'll be some more, once again, great live broadcasts coming up this fall. And since you're with us, especially if you're on YouTube, what I ask is that you like the video and click the red subscribe button. And then there's a little bell icon. If you click the bell icon, there you can see it right there on screen. You got a notification when we're live or when we post a new video. So once again, thank you so much. And thanks to our friends at Emond Harnden for doing such a great day. Hope to see you real soon. Bye-bye, everyone.